When we invest in ourselves, we all shine. Together, we are Black beyond measure.
Welcome back to the Black Table on the Black Star Network. I'm your host, Greg Carr, and this is our weekly hour devoted to exploring ideas and subjects of special importance to people of African descent and to others fighting to build a better society. Well, it's been a busy week and a busy first few weeks of the October term of the Supreme Court of the United States of America. And we, of course, in election season, and elections have consequences, particularly when you don't let sitting presidents appoint Supreme Court justices. And with the so-called conservative supermajority on the Supreme Court, everything seems up for discussion and up for revisiting. And as we have seen already from last term in the case of Dobbs versus Jackson Women's Health and the elimination, the reversal of Roe versus Wade and 50 years of precedent, everything perhaps is up for reversal. And well, we just heard the affirmative action case that we've all been anticipating being argued before the Supreme Court, Students for Fair Admission, which ostensibly is a organization devoted to fairness for folk of Asian descent, although no Asian plaintiffs seem to have been involved, but against Harvard University and North Carolina, University of North Carolina, ostensibly taking on the issue of race in college admissions. And so, we couldn't resist the opportunity to reconvene our regular legal roundtable. And we are particularly happy that these two professors, these two sisters, are joining us on such quick notice. And of course, we have back Professor Angie Porter from American University, the Washington College of Law, and Professor Valethia Watkins from Howard University, Department of Afro-American Studies, and the Women's Studies program, graduate program. Welcome back, professors.
Thank you. Good to be here.
Excellent. Well, it's good to see you all. I know you all have been talking about this regularly. So we're going to spend this hour really unpacking what we saw and what you expect will come of the arguments in Students for Fair Admission versus Harvard versus the University of North Carolina. So could you help us initially by letting us know, what are these two cases? I imagine folk kind of know generally they involve affirmative action, but what's going on there?
Well, I guess I'll start us off. So we're looking at cases against public and private university, and that's by design. Students for Fair Admissions being a kind of a litigation think tank of sorts backed by right-wing legal strategist Edward Blum, who also was behind the Shelby County v. Holder case involving the Voting Rights Act. That case essentially gutted the Voting Rights Act. And the other case, Fisher versus University of Texas, Austin. So this is, first off, this case shouldn't be seen in isolation. This is part of a multi-pronged attack, really. It's a matter of the retention of power of whiteness in this country, because as you see, it's backed by someone who's thinking of not only admissions in higher education, but voting rights at the same time. So, I'll start with that. The case itself is challenging the consideration of race in college admissions. It's seeking to overturn a case from 2003 called Grutter versus Bollinger, which really set the stage for diversity, recruitment and admission at higher education, and sets the stage for the discourse around diversity in hiring on the whole across institutions, even outside of higher education.
Thank you. I mean, and you may want to, perhaps we could look at this a little bit, Professor Watkins. Thank you, Professor Porter. Ed Blum, what is his stake in this? I mean, I've heard him described as a libertarian. I've heard him described as a conservative, but ultimately, why is he so hell-bent on this agenda, as Professor Porter said, between voting rights and now affirmative action? Who is Ed Blum? How should we be thinking about him?
Well, this organization is definitely phrased in a way to seem like it is representing students, but it is an organization that Ed Blum, who is a conservative activist, he is the president of the organization. The other member of the organization is the person, Abigail Fisher, who he recruited to try to destroy affirmative action in 2016 with the Fisher versus the University of Texas case. So he is not just a conservative, and these are not organic cases. These are very strategically calculated, premeditated cases as a part of a larger movement that Professor Porter mentioned. We have to continue to connect the dot. And this is people who were not happy with the outcome of the civil rights movement. And this is a counter democratic movement. This is to dismantle a lot of the gains that were achieved during the civil rights movement. And so on its surface, he initially tried to use white women to dismantle affirmative action. That did not work in the Fisher case. And so he very calculatedly decided that he wanted to use Asian American students as a front for what is really a white nationalist agenda. And so he figured that if he could divide and conquer different groups, pit them against each other, that would ultimately lead to the victory that he wanted to achieve. Mm-hmm. So ironically, we have a case that is, especially with the Harvard case, that is alleging discrimination against Asian American students, when in fact the lower court, which is closest to the facts, the fact finder, concluded conclusively that the affirmative action admissions program at Harvard did not discriminate against Asian American students. So the fact that this case is before the Supreme Court is really a reaction to the fact that this is an activist court. This court is functioning as a political arm of the Republican Party and the conservative movement. And so that's how we're here today.
And in fact, this is good. And this being the Black Table, of course, there's been a lot of coverage. People might have been aware of these kind of general framing issues, but we want to get right down to the questions that really we should be thinking about, particularly people of African descent, around judicial supremacy, the legitimacy of the court, a question of class. This came with my class at Howard Law School the other night as we were talking about this. The fact that most people who go to college in this country go to schools that don't use race as a criteria for admission. And that would include all the HBCUs, the community colleges, most of the public colleges. And we'll talk more about that in the coming segment. But in terms of the politics, as you raise it, Valethia, and now we can kind of, we all know each other very well. So let's just, we get loose with this. 6 justices, seemingly incoherent. And I know, Angie, you listened to all 5.5 hours of these arguments. 5 lawyers, 3 argued on behalf of Harvard and UNC. 2 of the people on the SFFA side are former clerks of Clarence Thomas. In the next segment, we're going to kind of parse through some of the oral arguments and what you all saw in that. But as we kind of begin to wind to the close of this first segment, how did we get this court? I mean, how is this court assembled? You bring up politics. I don't know if either you want to make a quick comment on how we come to the court that we have now to revisit something that nobody was asking to be revisited except these folk with this political agenda. Is this court really now just basically a political assemblage?
Absolutely.
Yeah, absolutely.
No, go ahead. Go ahead.
Professor.
Well, thank you, Valethia. Yeah, what you said earlier on, that elections matter, is right on point. If you look at the trends of the U.S. Supreme Court, going back to its origins, but particularly, I think one good touch point would be right after the Civil War. Since then, the trend has been, who is the president? Who is appointing the justices? And you can track what they're doing based on that. So if you look at recent history, this court is comprised of appointees of Republican presidents since the time of the Warren Court, the first court that they said was an activist court, the one that unanimously decided Brown versus Board of Education. making unconstitutional the principle of separate but equal in the education sphere. The court that's, interpreting the Civil Rights Act of 1964, the Voting Rights Act, that court creates most of the rights that many people today associate with the Supreme Court.
Before you go,
long after that era. Go ahead. I'm sorry.
No. I was going to ask you before you go on. Is it too much to say? Is it going too far to say that prior to the Warren Court, that the federal bench, and particularly the Supreme Court, as it relates to issues involving us, people of African descent, has been fairly consistently conservative?
Oh yeah.
That's a truly remarkable thing. People think the courts have had, but we really didn't start winning until the Warren Court, huh?
Essentially, yeah, absolutely. And so the Warren Court is like that's an exceptional.
It's an aberration.
It's an aberration. Yes, that's what I was going for.
Right, and that's why even when Thurgood Marshall was on the bench and he was very steeped in history, he basically said when he tried to hold off them dismantling very early on he tried to hold off the dismantling of affirmative action. He basically said we have to look to other branches, Congress, not the court, because he understood that the court has been has been conservative the vast majority of the history and has narrowly read the 14th Amendment to protect corporations more than it protect Black people, when the legislative history was that it was specifically designed to advance the interests of Black people in the context of just coming out of slavery during Reconstruction. So
let's hold that over to the next segment. We're going to take a break here in a moment. But it reminds me, Thurgood Marshall, who used to, as he was interviewing his clerks, one of the questions apparently he used to ask them is, do you like writing dissents? Because by then, of course, he wasn't the Warren. It wasn't the Warren Court. It was the Burger Court, of course, as we know. And I hope that you all will continue to help us understand the context for what happens to affirmative action in the 70s that led us to where we are today, and the change in the interpretation of what affirmative action means. So with that in mind, we're going to take a break. And when we come back, we will continue with Professors Angie Porter and Professor Lethea Watkins here at the Black Table, working through this idea of affirmative action, which we're pretty sure is going to end soon. So back in a moment.
We've got to stand up. Republicans are banning abortion rights, tearing down democracy, blocking progress. But when Democrats stand together, we win. Because we voted, Democrats stood up for Black lives, voting to ban police chokeholds, stood up for Black women, putting one on the Supreme Court, stood up for our families, lowering cost of health care and prescriptions and capping insulin, and stood up for millions by slashing student debt. This November, let's stand up together and keep making progress.
It's time to know your rights. If someone is questioning your right to vote, call or text 1-866-OUR-VOTE. For more information, call or text 1-866-OUR-VOTE.
When we invest in ourselves, we all shine. Together, we are Black beyond measure.
Welcome back to the Black Table here on the Black Star Network. We're discussing the affirmative action cases, SFFA versus Harvard and the University of North Carolina, with Angie Porter and Lethea Watkins. Profs, when we left, you all were beginning to walk us through that aberration in Supreme Court jurisprudence known as the Warren Court. How long did that court last? And the affirmative action case that kind of is at the heart of a lot of this, the Bakke case, was that the Warren Court? A decision of the Warren Court? Or how do we get to the case that basically defines the way we talk about affirmative action today?
Well, it's interesting because you mentioned the dissents. None of these arguments are new. You find the arguments that are proffered in SFFA. You find those arguments in the dissents from the 70s, or from the, we'll talk about Bakke in a second, from Grutter. You find all of this there. So it's It's
And
all
Grutter was decided when? These two, the Grutter and Grass.
Grutter is decided 2003. Baki's 1978.
Mm-hmm. And that was what, the Rehnquist court and the Berger court?
Yes.
Okay. Okay. And the court is getting, after that kind of watershed aberration moment, the court begins to claw back this revolution that Belethia was talking about in the 1960s. Is that what they doing?
Yeah, and track the presidents too, and the presidential appointments of the justices. But quickly, really we could start with Baki. We could really start with the Civil War. I feel like every time we come and talk with we start with the Civil War.
Listen, I'm gonna tell you in a minute, y'all gonna talk about these arguments, but listening to Ketanji Onyeka Brown Jackson and Sonia Sotomayor, they living in the 19th century. I'm loving this. So please set the stage. Yes.
After the Civil War, we get a situation where the South is just utter terror. They are terrorizing Black people. And the Reconstruction Congress is passing, trying to get bills through. I believe it was Andrew Johnson, the president, tries to veto a civil rights bill. They override his veto and realize, oh shoot, we better amend the Constitution because we have this president who's adversarial to our efforts to help Blacks in this country. So the 14th Amendment comes.
Hardcore legal conversation, but that Civil Rights is the Civil Rights Act of 1866, which predates and it's still good law, by the way. So I mean, people, shout out to Byron Allen, who has used it to his own advantage. But anyway, so is that where the 14th Amendment comes from? Congress is trying to. 14th
Amendment, yeah.
But the 14th Amendment is necessary because of the Dred Scott decision that said no Black person was a citizen of the United States, slave or free, and neither do any Black person in this country have any rights a white person is bound to respect. And so that was the law of the land. And so the 14th was necessary to confer citizenship, but also it gave us the Equal Protection Clause. When so many people are talking about equal rights, that is what they're relying on. So the 13th, 14th, 15th are the Reconstruction Amendments. And ironically, but for the Reconstruction Act of 1867, putting the South out of the United States, except for Tennessee, until they agreed to ratify the 14th and 15th Amendment, likely they wouldn't have passed. And so this is a very conscious, race-conscious Congress that is trying to stop the re-enslavement of Black people, which the Black codes and which the whole slavery by another name was taking place.
That's right. And when they say,
No, I was going to say very quickly, for not just the law students, but these high school students and folk watching the Black table as the numbers continue to increase, you need a 14th Amendment because, as you say in Dred Scott, Roger Taney, the Chief Justice, basically invents two types of citizenship because there's already a 5th Amendment that says there's equal protection, but the 14th makes the 5th apply to the states as if it shouldn't have applied all along. But go ahead. I didn't mean to interrupt you, Angie. Go ahead.
Oh, it's okay. This is all relevant because the reason we're talking about the 14th is because all of the arguments today they come from the 14th Amendment. And
the 14th Amendment says what, very quickly, just a basic statement?
It has multiple clauses. As Dr. Watkins said, 13th establishes citizenship. 14th Amendment has various clauses. The main clause that's being referenced today is the Equal Protection Clause, essentially saying you cannot treat citizens differently. And they know who they're talking about. I mean, you can look at the legislative history. Sometimes it expressly references race. But they're essentially saying there has to be equal protection under law, all citizens.
Which in the North Carolina redistricting case, Justice Brown Jackson just reading them for filth by reading the legislative record, right? You know what they were talking about.
Alabama.
Alabama. Yeah, not North Carolina, Alabama, right? That's right.
Mm-hmm. Yeah. And when they say race conscious and race neutral, race is a proxy word for Black. What they're talking about is Black conscious.
A direct word if we look at the legislative conferences on the amendment. So when does this thing move from a direct word for Black to a euphemism basically for white, which is what it seems like that's what Brown Jackson was arguing from the bench and she was grilling these lawyers about, wait, if they can't mention race, doesn't that basically preserve standing for whiteness as an advantage?
Now we're talking. I mean, this is, I guess, my point, and I'll end here and get out the way.
No.
Now we're talking. So the reason we keep going back to 1868 when the 14th Amendment is adopted is because it's clear at that time in history who it's talking about, who it applies to, what the intent is. We're talking about protecting Black people because there's a whole separate regime set up for them after the Civil War in the South. They're being terrorized. They're being prevented from participating in political process. These arguments in these cases flipped the 14th Amendment on its head. So what Justice Jackson and Justice Sotomayor are doing are trying to flip it back right side up and remind people, even though they don't need reminding, they're being disingenuous, and expressly tell people, you have flipped this on its head. All along, the 14th Amendment was meant to avoid excluding and separating people based on race, based on their Blackness. And you are now saying race can't be mentioned at all to benefit Black people or others.
So
that's antithetical to the origin of the 14th Amendment. So
when, and thank you. And Valethia, as you were talking about the 14th Amendment being used by corporations in the back half of the 19th century, it takes 100 years for Black people to fight their way back into this with the Civil Rights Movement. The Civil Rights Act of 1964, the equal protection claims there that are drawing on this. Heard a lot about Title VI in these arguments. Given that second Reconstruction moment that we often call the Civil Rights Movement and the birth of affirmative action, was affirmative action originally designed 100 years after the Civil War to connect to this original meaning of the 14th Amendment and perhaps try to help Black people and address previous discrimination?
Right. So if we actually, we're so used to saying the word affirmative action, but let's think about what it means, taking affirmative steps to bring about equality. So, the stronger argument in favor
of equality, not diversity.
Not diversity. The strongest argument for affirmative action and what it was originally resting on in 1965 was to remedy past discrimination. There were overt years upon years where the Constitution was not colorblind, that it was used to discriminate legally against Black people. And so now are you talking about remedy past discrimination, but its present effect and its ongoing discrimination? Because when did racism end? Since racism didn't end, since white supremacy didn't end, it is still ongoing and it never came to an end. And so the court, in Bakke, it begins to switch the stronger rationale for affirmative action to diversity. So from remedy, like right now, they don't even talk about remedy past discrimination, present effects of discrimination, and ongoing discrimination. They fictively act like that does not exist. And so
all three of us have mentioned Bakke. When we say Bakke, what do we mean? Somebody's saying, they keep saying Bakke. What's Bakke?
That's the 1978 case, the Regents of the University of California versus Alan Bakke, who was it's a medical school case. It is the first case testing affirmative action, and Bakke was a white applicant who was not admitted to the medical school. And at that time, the school had set aside 16 seats out of 100 for minorities. And understand, minorities mean all minorities, not just Black people.
Non-whites.
So yes, non-white, 16 out of 100. And so the court was, divided, and Lewis Powell, came in and split the baby. And baby. What you said was that, this idea of quota, that's when the quota becomes this loaded term and say you can't have firm targets or fixed numbers. And so quotas were ruled unconstitutional and not
Except
permissible.
if you're talking about HBCUs, because I was an undergrad at Tennessee State when the federal district court said that they want Tennessee State to become 50% white by 1993. So you can throw numbers around when you try to attack HBCUs, but when it comes to white, but no quotas, huh? This is the end of quotas.
And that's the kind of not tricky, but pernicious way that race is used in this society. It's very slippery. Sometimes people use it to conflate it with culture. Sometimes they use it to conflate it with racism. Sometimes they use it for whiteness, blackness. And this ideal that the invisible whiteness, the hidden hand of whiteness, as if white people are raceless. So their race is unmarked. And so it's slippery in how it's used. So Professor Porter could tell you the other half of Bakke. So quotas are out. And
I'm only pressing because it seems like we're doing a whole semester of law school in 30 minutes or an hour. But so is this what Sotomayor and Brown Jackson were talking about when they were talking about the fact that Harvard and North Carolina, race is only one factor that they use among many others? But two things. Number one, as Sotomayor is saying, so you telling me that if a person is the first Latina or the first Black person to be student body president at their high school and it's all white except them, they can't mention that they're Black or brown? When Ketanji Brown Jackson is like, so somebody who comes up through this particular life writes in their personal statement that they are Black, you saying that they can't? Wouldn't that mean that if you were white, that you would get an advantage? Is that what they were trying to get at? In terms of this question of diversity, not now by excluding everything but whiteness retains its power.
Right. It's not neutrality by any means. It is willful ignorance of a certain trait. It's reckless disregard of race. And so you're not focusing on race. You are intentionally thinking about it and ignoring it. And that's really the inherent flaw of this color blindness idea that it permeates this whole argument.
This is very important. In fact, let's take a break here and when we come right back, because our friend, a great beneficiary of affirmative action, Gullah Geechee out of Georgia, claimed that he didn't know what diversity was. This former head of the Equal Opportunity Commission. But at any rate, when we come back, we're going to explore this line that you all have just laid out for us. Back in a moment with Angie Porter and Valethia Watkins, our regular legal roundtable, as we begin to parse the oral arguments that we heard in Students for Fair Admission against Harvard and against the University of North Carolina. Here at the Black Table. Back in a moment.
Exercise your right to vote. If the lines are long or you're getting turned away, call or text 1-866-OUR-VOTE. For more information, call or text 1-866-OUR-VOTE.
When we invest in ourselves, we're investing in what's next for all of us. Growing, creating, making moves that move us all forward. Together, we are Black beyond measure.
We've got to stand up. Republicans are banning abortion rights, tearing down democracy, blocking progress. But when Democrats stand together, we win. Because we voted, Democrats stood up for Black lives, voting to ban police chokeholds, stood up for Black women, putting one on the Supreme Court, stood up for our families, lowering cost of health care and prescriptions and capping insulin, and stood up for millions by slashing student debt. This November, let's stand up together and keep making progress.
Welcome back to the Black Table here on the Black Star Network. Don't forget, support the Black Star Network, spread the word. We're continuing to grow and build. And you see the kind of quality programming we have here on the network. We're joined again by Valethia Watkins and Angie Porter, two professors who are helping us think through this question of the affirmative action cases we've seen. So when we left, you all were we were right about to enter the room for these oral arguments. You've laid us out with the origins of the 14th Amendment, the Civil Rights Act of 1964, Title VI, the whole question of Bakke in 1978, and then you drew the roadmap from there to Grutter and Gratz in the early 2000s to preserve affirmative action. Maybe let's linger there on a moment. How do you connect then after this whole rationale from the affirmative action goes from addressing discrimination to diversity. What role then did these cases play in the early aughts in 2003, 2004, the Grutter case? What they extended affirmative action. I kept hearing Amy Coney Barrett saying, well, how many more years? How many more years? I'm like, y'all are damn near incoherent in this. Where did she even come up with that? And what does Grutter have to do with that?
If I can sit back in Bakke for a second.
Well, yeah, of course. Yeah, of course.
I don't think this gets enough discourse. Once we have Justice Powell and Bakke, by the way, Bakke is not a mandatory opinion. It doesn't have a lot of weight because it was what's called a plurality. There was no majority in that case.
Oh, explain that to us, because people think they decide it's 5-4 or 6-3. What is a plurality, and why is that important here?
That means you have no majority. You have multiple opinions. Maybe 4 people write one thing, 4 people write another, 3 write one thing, 3 write another, and the remaining 3. So they're not unified on the rationale behind the result. But the opinion that had the most staying power from Bakke is Justice Powell's decision, as Alethea mentioned. But we need to really talk about that because it answers your question. This is where the U.S. just went off the rails. And anything we talk about after Bakke, we're in a nonsense framework. So all these arguments we can talk about, like,
let me write that down. I got willful, reckless disregard, and now nonsense framework. Y'all chop the bar. Go ahead.
Anything we talk about when it comes to affirmative action after this, now we're just we're dealing in nonsense. We've been dealt a bad hand. And the example I'm going to raise is Brazil. Brazil. The enslavement capital of the Western Hemisphere has taken a different course. They have said quotas are fine. Quotas are necessary.
That's right.
Remedying past discrimination is the premise for their legal framework on race. They have never disavowed that. The U.S. disavowed the premise of remedying past societal discrimination. And they nominally in Bakke retained that, and in Grutter, 2003, retained that, if your institution individually discriminated in the past, you have to prove that. You have to show that there was discriminatory intent, which legal folks like all of us know that is extremely hard to do.
Beyond us being here speaking English and not being in Africa,
right? That doesn't suffice. So they are like, they're going to make it exceptionally hard for you to do the remedying past discrimination. You can't do it as society as a whole. Brazil said, that doesn't make any sense. So then we get to this diversity thing, which is established by Justice Powell and picked up by Justice O'Connor. Here's the thing. There's another line of affirmative action cases in hiring and things. So they're talking about remedying past discrimination and diversity. When you talk about the remedy, and Alethea mentioned this earlier, when you talk about remedying, logically, theoretically, there has to be an endpoint because at some point you will be made whole. This is the theory of it. But, for all of us Black folk, we know, okay, sure. There might be an endpoint. It's going to be multiple lifetimes from now. Right. It might be another 500 years if this country is still here. Right. Then we'll be remedied. But okay, sure, there's an endpoint when everybody's made whole. This is when it gets just totally off the rails. Diversity becomes the compelling state interest that is permissible in the U.S. in order to do affirmative action. Diversity is this, wishy-washy thing that honestly never gives Black people power. At most, it helps Black people be represented at the same level that they are in the greater society, which means we're always at a small percentage in these institutions. So there's never power. But okay, diversity. O'Connor, in 2003, puts a timeline on that. And she's borrowing that from other Supreme Court cases. She doesn't invent that.
And this is Sandra Day O'Connor, first Justice Supreme Court, appointed by Ronald Reagan, who's sitting there in this case. And this is University of Michigan case?
Yes, University of Michigan.
They're using race as a factor in admission.
Yes, but get this.
Okay.
She conflates endpoint logic. Remember how I said if you're remedying something, it makes sense for there to be an endpoint, theoretically.
Sure.
With diversity, she brings it to diversity. She says there has to be a logical endpoint. Does it make sense for there to be a logical endpoint for diversity? Theoretically, no.
No. Nonsense.
Diversity is a check on racism.
So what did she say? 1,000 years, 500 years, as you say?
She said she pulls a number out of the clear blue sky.
Well, I mean,
25 years.
It's an arbitrary number. 25 years.
25 years.
Wait, 25 years?
Right.
Wait, when was it? 2003, 4?
2003. So we're in 19 years now. And so they're not even going to pay attention to the 25 years.
So that's why they were saying from the bench during orals, is it going to go 4 more years? They still using this. Again, before we can critique that, okay.
We need to critique why is there an endpoint period for diversity.
Right.
And you know why? It's because whiteness views these measures as a punishment. This is the same mentality that comes out of the Civil War, the post-Civil War era of Reconstruction. The South will rise again. This is the same mentality. If you're viewing check on racism, anti-racism as a temporary measure, as a punishment, that makes no theoretical sense. And so we ought to challenge the very premise of that endpoint thing. The tragedy of the arguments is that we have to play with the argument. Nobody said, hey, justices, it doesn't make any sense that there's an endpoint. That was wrong.
Nobody yet. But I mean, at some point, I mean, clearly, Kagan, not so much, but certainly Brown Jackson and Sotomayor seem to be in the tradition of Thurgood Marshall and Brennan and others as that majority eroded and they're writing dissents, setting up maybe for another cycle when they do have the majority. But what is going on in Clarence Thomas's mind? Because let me say that, I mean, views these measures as punishment. So they got a redemption agenda. Clearly, what is this black man doing? We as you know, we had Corey Robin on a while back, and in his book, we were arguing about Clarence. What is Clarence Thomas's argument, particularly since he had 2 clerks in front of him arguing for this nonsense logic you're talking about?
Well, he certainly is the front man for this narrative that equality is racism against white people, and that white people are being harmed by equality. And
I'm writing all these quotes down. Equality is racism against white people.
And so, as Professor Porter is saying, they are not only trolling us, they're flipping the whole argument on its head. And so they're saying, oh yeah, what's diversity? And looking at the comments across the internet, these conversations are not for us. These are buzzwords that they're giving ammunition to this larger, group of people who are just hearing quotas. They act like quotas are still legal and happening right now. They are giving ideals about how white people are being severely harmed. Now, not even mentioning the entire legacy debacle about diversity. So for them, diversity is fine. All kinds of diversity is great, except for racial diversity. And so what that trends
you went by that a little moment. The question of legacy. I think I read somewhere that over 40% of the white undergraduates at Harvard are there because they're either children of donors or interests of dean or somebody went to school for, and that their collective GPA and test scores are lower than everybody. Is that what you mean by legacy?
Yes. So as a part of this case, part of the fact finding part of this case, they found in 2019 that 43% of the admits into Harvard were legacy. It's ALDC. It meaning that they admitted legacy people who were the children of alumni, people who were children of donors, the children of the faculty and staff, and recruited athletes. They comprised of 43%, almost half of those people who were admitted. They were put on a special dean's interest list, which is a euphemism for these people. We're going to put a thumb on the scale. And so
affirmative action. I'm going to raise my drink up.
Affirmative action. And they also found that if you look at the record of those people, like Jared Kushner, whose father donated, otherwise he would have been turned down. When they looked at the records, all of those people, not all, but many of the people who were given special admissions under legacy, they would have been rejected if they had to go through the regular process. So that set aside is never challenged by Edward Bloom or those people who are against racial diversity, but gender. Kagan alluded to this. Many schools have found that if you're going strictly by academic credentials, many of these schools will have more white women than they have white men. There will be an imbalance. And so schools are quietly doing affirmative action for white men whose records aren't as strong as against white women. And no one has a problem with that. So gender, affirmative action, again, going back to history, white women have been the greatest beneficiaries of affirmative action. So they don't challenge gender affirmative action. They don't challenge legacy affirmative action. They don't challenge wealth privilege affirmative action. All kinds of affirmative action are okay, except for when it comes to remedy ongoing. Forget past. Well, we don't need to forget past. Let's have it all. But we're talking ongoing discrimination. There is no reason for this country to fund education based on the housing, the taxes of the housing. So it's built in, it's in the air around us, the disparities in schools, the disparity in resources. And that's how you get to the outcome. And not even mentioning that test scores and all of this are cultural products. They are not objective measures of intelligence. So you don't even begin to have this heavy reliance on test scores until we achieved civil rights victories. And that's when people retreated to the numbers. Right. So they could pretend that they're being objective when there's nothing objective about this process.
That's why test scores need to go away as a response to this.
And people are starting to do that. I mean, in fact, we only got one more segment left. We're probably going to have a part 2 of this, and we're going to have this legal roundtable again and again. This term is just off the chain. But you mentioned Kagan, and I don't know, maybe as we kind of close this moment, Angie, I think at one point she remarked to one of the lawyers that it appeared to his view, I think it was Strawbridge, that just doesn't look like you care whether our institutions look like America. I mean, so that place that you were talking about, this place that doesn't exist yet, this America, these people seem to want to just basically act like, this is a white man's country, white man and white woman, I suppose, and everybody else just go to hell. The institutions don't need to look like that.
Yeah, she unclothed their argument and just showed it for what it was. This is about the power of whiteness. It is not about Asian Americans. It is not about the 14th Amendment. So they're just stripping all of their costume off. And that is the answer. What also, maybe this we can confront next segment, but what I'm really wondering is, what's Kavanaugh going to do? Because Kavanaugh uses affirmative action to hire his clerks.
Oh, you know what? Pause right there. We're going to pause. When we come back, we're going to squeeze a lot in this last block at the Black Table with Lethea Watkins and Angie Porter on the question of affirmative action in higher ed and beyond, here at the Black Table.
Know your rights before you vote. If you have any questions or a problem voting, call or text 1-866-OUR-VOTE. For more information, call or text 1-866-OUR-VOTE.
When we invest in ourselves, we're investing in what's next for all of us. Growing, creating, making moves that move us all forward. Together, we are Black beyond measure.
We've got to stand up. Republicans are banning abortion rights, tearing down democracy, blocking progress. But when Democrats stand together, we win. Because we voted, Democrats stood up for Black lives, voting to ban police chokeholds, stood up for Black women, putting one on the Supreme Court, stood up for our families, lowering cost of health care and prescriptions and capping insulin, and stood up for millions by slashing student debt. This November, let's stand up together and keep making progress.
Welcome back to the Black Table here on the Black Star Network. Spread the word, and we're going to continue to build here at the Black Star Network. And we're here with our regular legal roundtable, Angie Porter and Valethia Watkins, discussing the affirmative action cases. Let's resume right there. What is Kavanaugh going to do? I didn't realize that he uses affirmative action. He has said that.
Yeah, he's been doing that since he was at the DC Circuit, since before he was on the Supreme Court. He's always hired a Black clerk and a woman. But
he's not forced to do it. He's just doing it voluntarily.
Right. Right. So I guess maybe that would be his. But still, like, you're doing it. So how are you going to wrap this rationale up?
They're going to do what they want to do. That's what we're talking about, isn't it? Right. This is raw, naked power. They're not following any principles. If they were, this is being totally different than Dobbs. So in Dobbs, he said, I don't see abortion in the Constitution, so we got to disregard that. Well, I don't see the word colorblind or race neutral in the Constitution. And so I see something different in the 14th Amendment. And the other thing that Dobbs relied, quote unquote, on history. Now they cherry picked the history. Yeah, this case is totally talked about ahistorically, out of context, in the abstract. So
let's just drop this in and keep going. In terms of them calling themselves strict constructionists and originalists, it seems like in this issue, and she's really lining out her first few months on the bench, Ketanji Brown Jackson seems like the most originalist member of the Supreme Court at this point. But
none of them are. None of them are. Okay. Yeah, they're going to tap into what they're going to tap into. It goes back to what Lisa just said.
Reckless disregard, I think you said.
Right, and so you're going to see that when I say they're going to do what they want to do, you see Roberts trying to saying, we're in trouble with the military, because the military said, look, we have racial strife and tension in the military when you try to put all white or officer corps over an enlisted group of people that are diverse. But then this reminded me, and when he said that reminded me of the, going back to the 54th and the Civil War, the all color units that they would put white officers over. Anyway, so he already signaled that he's trying to give the military a carve out. And so he tried to.
You think he may do that?
Yeah, he
didn't have the numbers, which is why Kavanaugh is important, huh?
Right, but he was trying to split that baby and talk about the differences in the military academies, what they call the service academies, as opposed to regular universities and colleges. But the lawyer for the military and the government pointed out that a lot of their officers also come from ROTC programs at public universities or at private universities. Like Howard. And so you can't sever it out. You can't sever it.
Wow. Right. Well, and this is the thing. I mean, not that I'm saying they are going to not do what we expect them to do. I mean, they're gonna get rid of affirmative action, but plurality decisions are a possibility.
Do you think so?
Complicated. It gets complicated because now we're just talking about rationale and the breadth or narrowness of a decision. Roberts, as we know, is anti-affirmative action, but he's got this whole chip on his shoulder about the legitimacy of the court. And one option is to essentially gut Grutter by saying, by keeping the decision narrow and saying that these schools are violating Grutter without overturning it. Right.
I think we're gonna have to have another session because we're gonna have to do a little bit of a lightning round here to get enough. You say everybody has something to hold on. So first of all, who do you expect to write this opinion? If it's plurality opinion, I guess everybody could write. But I mean, Clarence Thomas, for example, I know he's been waiting his whole 30 years on the bench. I mean, who's gonna write this opinion, do you think?
Thomas.
Damn. Clarence Thomas gonna write his opinion. Okay, all right. So we kind of know what you expect. Okay. Does this continue to erode the idea of judicial supremacy? Are people going to trust it? We don't know what they're going to say, but what do you think?
Well, the legitimacy of the court is it's really revealed now. People have more clarity, and in some respects, this has been going on all along. So
Right.
we now can be, it's more overt. It's the same thing. All of this mindset, what we see with white nationalism, it never went away. But every time we said it before, as recent as when Jamil Hill called Trump a white nationalist or pro-white supremacy and got fired from her job, that people were still said, anytime we say it, they gaslight us and say it didn't exist. So what Trump did is just reveal what has never went away. And so you can see that if you even watch The View, some of the women who are normally liberal were very much just eating up what Clarence Thomas was saying about diversity. And when the lawyers were being intellectually dishonest by saying race alone, like when they kept saying check the box, like as if Black people check the box, I'm Black, and then they say, here's your keys to the dorm and come on in.
Right.
That is happening nowhere. It's never happened. They kept check the box. You just say race and I'm Black. You're admitted.
Exactly, you're admitted. Well, let me squeeze this in because again, I mentioned it earlier, but I really I think we need to hear what you all have to say about this. You know, what does this change when they end affirmative action? Again, most people who apply to schools don't go to schools where race is used as any type of admission. I mean, you know, we didn't go to them. I mean, well, Letha, you did. You went to Michigan and Ohio State, you know what I'm saying? But Angie and I, HBCU Negroes, and no HBCU uses race. The community colleges don't use race. What is the significance of this? Are we talking about a class structure where some people are trying to get, we had Natasha Warku on here. She talked about her book, Race at the Top. White people are going to change the rules if too many Asians get in. They're going to say no test scores, you know, extracurricular activities. What is the implications of this case for regular people?
It's wide reaching. I mean, this is public and private universities. We don't have to get into the legal structure there, but this is all universities and private institutions, corporations, other organizations take their cues from this jurisprudence. So every recruiting committee you done been on, every hiring committee, they talking about holistic review. That's going to become a bad word, a bad phrase. But here's what's going to have to happen. And I'll just say this and let it lie. At a point for the higher education institutions, there's going to have to be resistance. That's going to mean open defiance.
What's that going to look like?
Well, these institutions are going to have to figure out what they value and if that, or in how they operate. And they will figure it out. And if that means that they remain, none of them are doing, to borrow your phrase, Dr. Carr, none of these HWCUs are doing well on diversity in the first place.
And Letha knows, because, you know, when we were in law school at Ohio State, every last one of them people thought we were there because of affirmative action. Right. They never gave us nothing.
Right. So here it is. They're going to have to decide. That's on them. They're going to have to decide how to operate to bring our people into those schools. And if that means they don't, we need to stop going there. We need to stop applying to those schools. We need to stop applying to learn and work at those schools. And we need to stop supporting those schools in the ways that we support them. They want to go back to segregation. We could do that.
How about that?
Do that. We got HBCUs. We got TCCUs. We got HSIs. We could go back. But what does that mean for y'all, HWCUs?
Well, one of the things it should mean is that they need to stop underfunding HBCUs and other minority serving institutions. There has always been systematic discrimination in how they allocate state resources. So we pay in taxes. They owe us the financial investment that they have. We saw that during the pandemic. So when they cry broke, just remember all the money they gave out during the pandemic. But what does it mean? If we look at the long arc of history, reading the amici brief of several people, but particularly the HBCUs, even today, they said 80%, I'm going to quote statistics from the brief that they submitted. They said 80% of the nation's judges were educated at HBCUs. Half of the Black doctors in this country educated at HBCU. Half of the Black lawyers have been educated at HBCUs. 40% of Congress, the Black people in Congress, were educated at HBCU. They say in recent history, in terms of the number of students Howard has sent to science and engineering PhD program outstrip what Harvard, MIT, Stanford combined, Yale combined have submitted. And then we look at Howard with
what is that in support? Is that in support of affirmative action, or that's
in support that our own, even with affirmative action, where people are really creating the professionals is what HBCUs have done the entire time. So let's balance it out. And that's where you say the class thing. Affirmative action has not been open to the masses. Students who are in urban areas, they are been totally not benefiting from affirmative action.
People like us.
Right. The working class have not benefited.
Right.
The place that has really educated with less, making bricks without straw has been our institution. So, and we've seen since the George Floyd, Breonna Taylor mass movement that students there's been a resurgence in wanting to come here, go where you are valued and wanted and not just tolerated. And students have been able to say to their parents, the elite students, we're seeing a resurgence of that. And we have to balance that out too. Our students can't totally just say, oh, well, we're going to go with the same profile that Harvard would and leave out the working class and the poor that are important features of these institutions.
Morehouse, Howard, and Spelman are not the black Harvard. That's not a compliment. And Harvard definitely not the white Morehouse, Spelman, and Howard.
We got a different mission.
That's exactly right. Well, we should anyway.
Well, we should. That's the fight. That's the internal fight.
That is the internal fight. And on that note, I hate to bring this to a pause. I won't say a close because we still got this independent state legislature case coming up, the Indian Child Welfare Act, so many things. So we're going to reconvene this legal roundtable shortly as these oral arguments come. But I want to thank both of you all for carving out some time just to help us think about this, because y'all done put everything on the table. And thank you so much, Angie Porter of American University, Washington College of Law, Lethea Watkins, Howard University, Department of Africana Studies, and Women's Graduate Studies. So thank you all both for joining us. Y'all gave us a lot to think about this morning.
Thank you.
Thanks for having us.
Thank you all always. We'll see you again soon. So we're going to come back in a moment, clear the table, and prepare for our next session here at the Black Table. Back in a moment.
We've got to stand up. Republicans are banning abortion rights, tearing down democracy, blocking progress. But when Democrats stand together, we win. Because we voted, Democrats stood up for Black lives, voting to ban police chokeholds, stood up for Black women, putting one on the Supreme Court, stood up for our families, lowering cost of health care and prescriptions and capping insulin, and stood up for millions by slashing student debt. This November, let's stand up together and keep making progress.
Know your voting rights. If you are unsure where to vote or don't know if your polling location has changed, call or text 1-866-OUR-VOTE. For more information, call or text 1-866-OUR-VOTE.
When we invest in ourselves, we all shine. Together, we are Black beyond measure.
When you talk about Blackness and what happens in Black culture, we're about covering these things that matter to us, speaking to our issues and concerns.
This is a genuine people-powered movement.
There's a lot of stuff that we're not getting. You get it, and you spread the word.
We wish to plead our own cause. Too long have others spoken for us. We cannot tell our own story if we can't pay for it. This is about covering us. Invest in Black-owned media. Your dollars matter. We don't have to keep asking them to cover our stuff. So please support us in what we do, folks. We want to hit 2,000 people, $50 this month, raise $100,000. We're behind 100,000, so we want to hit that. Y'all money makes this possible. Checks and money orders go to P.O. Box 57196, Washington, D.C. 20037-0196. The Cash App is $RM Unfiltered. PayPal is R Martin Unfiltered. Venmo is RM Unfiltered. Zelle is Roland at RolandSMartin.com.
Welcome back to the Black Table here on the Black Star Network. Continue to support the Black Star Network and spread the word. Today, you saw another reason why the Black Star Network is so important. We just heard Professors Porter and Watkins lead us through a very complex issue, one that, to quote Professor Porter, is now dealing with a nonsense framework, the question of affirmative action. We're all waiting to see how the court will rule and how they will get to their dismissal of affirmative action. In that last segment, very interestingly, we heard both Professors Porter and Watkins make a call to Black institutions to really dig down to what Dr. Watkins said is our mission. HBCUs pay very close attention. And I can think about our conversation we had with Professor Corey Robin and his book, The Enigma of Clarence Thomas, where he makes the case that Clarence Thomas may see himself as a Black nationalist. And if we think about some of the things that Thomas has written in earlier cases about the value of HBCUs and why they're important, perhaps we might see a line in a Thomas opinion in Students for Fair Admission versus Harvard in North Carolina that might make that clarion call for Black colleges to do for self. Who knows? Wouldn't that be very interesting? Well, join us at the Black Table next week for another session. And thank you all for tuning in here on the Black Star Network. See you next time.
When we invest in ourselves, we all shine. Together, we are Black beyond measure.
When you talk about Blackness and what happens in Black culture, we're about covering these things that matter to us, speaking to our issues and concerns.
This is a genuine people-powered movement.
There's a lot of stuff that we're not getting. You get it, and you spread the word.
We wish to plead our own cause. Too long have others spoken for us. We cannot tell our own story if we can't pay for it. This is about covering us. Invest in Black-owned media. Your dollars matter. We don't have to keep asking them to cover our stuff. So please support us in what we do, folks. We want to hit 2,000 people, $50 this month, raise $100,000. We're behind 100,000, so we want to hit that. Y'all money makes this possible. Checks and money orders go to P.O. Box 57196, Washington, D.C. 20037-0196. The Cash App is $RM Unfiltered. PayPal is R Martin Unfiltered. Venmo is RM Unfiltered. Zelle is Roland@RolandSMartin.com.